Welcome, everybody, to our webinar, Employment Investigation and Social Justice, continuing the discussion. This is our first Labor, Employment, and HR session of 2022, and we're very pleased that you can join us today. Before I introduce myself and our speakers, please see the housekeeping slide that is up on your screen now. I'm very pleased to be here today with three wonderful colleagues. Cathy Chandler is an expert in occupational health and safety and workers' compensation matters. Rebecca Rossi has just joined us as an associate in our Labor, Employment, and Human Rights Department, and she had the pen on the PowerPoint presentation. Thank you, Rebecca, for that. Sarah Graves, a partner in our LEHR group. Sarah has 20 plus years of advising on conducting and litigating investigations. She's my go-to person whenever I have tough questions about investigations, and we have had great discussions over the years. And I'm Katherine Pollock. I've been an associate and partner here at the firm for the last 34 years, practicing labor and employment law with a particular emphasis on investigations. I'm also the chair of our firm's EDI committee and the chair of our partnership board. So let's take a look at today's agenda. We're going to continue a conversation that we started a year ago on investigations and the social justice movement that we find ourselves in. In particular, this year, we're going to be focusing on intersectionality at the same time as bringing you up to date on what's happening in the case law and at the federal level. We're going to take a look at addressing both historic allegations and those that are anonymous. We're going to focus on the continuing importance of procedural fairness. And finally, Sarah's going to be talking to us about how to conduct an investigation in a sensitive manner and considering lived experience. About a year ago, when we were talking about investigations and in 2021, we were looking at the Me Too movement in particular. This year, our theme is going to be in large part on intersectionality. That's kind of become the word of the moment. And I think intersectionality is best demonstrated in the workplace by the use of a word that was new to us this year, called misogynoir. That's a combination of two words, misogyny, hatred of women, noir, which is French for the English word black. And it's a particular word that is directed at misogyny directed at Black women in particular, misogynoir. It's a word that's been around since 2008, but it's only in this last year that it's kind of bubbled up to the top. And when we're talking about social movements, intersectionality, where people's personal characteristics overlap, we really want to emphasize this year how important it is for investigators to be aware of this intersectionality. Next slide, please. I'm going to ask Cathy to dive in to the federal update 1 year later. Cathy, over to you.
Thanks, Katherine. So it's been just over a year since the workplace harassment and violence prevention regulations under the Canada Labour Code came into effect on January the 1st, 2021, known as Bill C-65. And we thought we'd revisit some of the highlights of that regulation, particularly around the requirement to identify and assess potential workplace violence and harassment hazards or risks that workers may be exposed to in the workplace, which a lot of our federally regulated clients have been dealing with over the last year, and we've been helping them to do so. We also want to do a bit of a review of the arguably complex complaint resolution process contained in the regulations as well. And although the changes to the Canada Labour Code are the most recent legal changes respecting workplace harassment and violence, we can't forget that, over the past several years, we have seen stronger provisions respecting workplace harassment and violence enacted in provincial occupational health and safety statutes as well. Bill 132 in Ontario expanded on Bill 168 and certainly created more onerous investigation, reporting, and compliance obligations, especially with respect to workplace harassment. New Brunswick in 2019 amended its health and safety statute to include violence and harassment provisions. So at this point, really every province's health and safety statute contains provisions related to the prevention of workplace harassment and or workplace violence. So, perhaps in part because of changes to the legal landscape, we are seeing employees coming forward with complaints. We're seeing more bystanders come forward to report occurrences that they've witnessed. And we're seeing more of a focus from employers on really wanting to know and understand how to conduct effective workplace investigations. So looking at some of the highlights that you're seeing here on the slide, the highlights of Bill C-65, the first being that federally regulated employers are subject to obligations to protect employees from workplace harassment, from workplace sexual harassment, and from workplace violence. And another highlight that I mentioned is the requirement for a mandatory workplace assessment, really obligating employers to take steps to prevent violence and harassment from occurring in the workplace, really like you would treat any other occupational health and safety hazard in terms of identifying the hazard, assessing it, and then putting measures in place to control it. And the new regulations require employers, when they're doing their assessment, to consider certain elements when identifying risk factors, basically looking at the type of work that they're doing. So do they have employees that are interacting with the public or that are interacting with clients? Taking a look at the nature of work that's being done at the workplace. Are you requiring workers to work late at night, shift work, work alone? And then also looking at environmental conditions as well. So, is your workplace open to the public? Is it in a remote location? Is it isolated? As well as considering any prior incidents, also the potential for domestic violence to enter into the workplace, and then also looking at whether or not there are measures in place to protect workers' psychological health and safety in the workplace. So these are all things or requirements that we saw enacted by the new regulations that employers need to look at when they're conducting their risk assessments. So a lot of this is similar to what we see in provincial health and safety statutes that require employers to conduct workplace violence risk assessments. However, not all provinces require employers to assess workplace harassment risks. Ontario doesn't, for example, in its provincial statute. And I think that this is worth noting. The recognition that incidents of harassment can often escalate into workplace violence, and that employers need to take steps to prevent workplace harassment as much as they do workplace violence. And the new regulations have recognized this. Certainly, the federal regime is a lot more prescriptive than the provincial statutes with respect to setting timelines for the completion of a risk assessment process. Preventative measures need to be implemented within 6 months of the initial risk assessment under the federal regulations, and also qualifications of the individuals that are conducting your risk assessment and identifying your preventative measures to control those risks that you identify and assess. These individuals under the new regulations have to be qualified by virtue of their training or their experience or their education. And then another highlight worth noting, something that all federally regulated employers should now have in place, is their workplace harassment and violence prevention policy and completion of training on the policy for all employees. So the regulations allowed 1 year from the date that the regulations came into force for employers to provide their existing employees with training on their policy. So that timeline was up January the 1st of 2022. So I'm just going to spend the remainder of my time now on the legal obligations of federally regulated employers when it comes to investigating complaints of workplace harassment or violence. So we can jump to the next slide. So for federally regulated employers, Bill C-65 certainly brought about a number of new obligations, as I've been discussing, including this expanded and as I said, arguably complex incident resolution process. And we've got a summary of the process on the slide here. So negotiated resolution is really the starting point for the investigative process. Negotiated resolution is a form of informal resolution where the complainant, referred to in the regulations as the principal party, meets with the employer or the designated recipient. And the designated recipient is your human resources or your employee relations department, most likely for most employers. So meets with a designated recipient to discuss the occurrence and attempt to reach a resolution. And it's mandatory in accordance with the regulations for the designated recipient and the principal party to make reasonable efforts at this stage to resolve the occurrence before the matter is referred to an investigator. A negotiated resolution needs to begin within 45 days of the designated recipient receiving that initial notice of occurrence, and it can continue really right up to the point that an investigator has provided the employer with their report of findings. And the regulations really give employers some flexibility here in terms of what the negotiated resolution process might look like. So at minimum, it means meeting with the principal party to understand their complaint, understand the basis for the conflict, but it could also mean mediating the dispute between the parties. It could also mean commencing your organization's formal investigative process. So conducting interviews of the principal party, of the respondents, of any witnesses, reviewing relevant documentation, collecting physical evidence, really making your findings of fact and determining whether or not workplace harassment or violence took place or not. And then unique to the federal sector regulations is the inclusion of conciliation as part of the complaint resolution process. So if an incident isn't resolved by way of negotiated resolution, then the principal party and responding party can attempt to resolve the occurrence by way of conciliation. And really anyone can act as a conciliator. Usually it's going to be a mediator, and we usually suggest to employers that they do have a short list of mediators available to them. In order for conciliation to take place, both the responding party and principal party need to agree to it, and they need to agree on who the conciliator is going to be. And then finally, if the incident can't be resolved by negotiated resolution, if it can't be resolved by conciliation, then it can be resolved by investigation if the principal party requests it, at which point the employer must provide the principal party and responding party with notice that an investigation is going to be carried out. So this is the investigative process that starts at, if you're very familiar with the regulations, section 25 of the regulations, and requires the investigator to be mutually agreed upon by the parties. It requires the investigator to have specific training and to provide the employer with a written report of findings. And in terms of completion of the complaint resolution process that we've been discussing, the employer's got a 1 year timeline in which to do so. And that includes implementing any recommendations that come out of an investigator's report that have been jointly agreed upon by the employer and the workplace committee. So provincial statutes, just going back to provincial statutes for a second, they also require employers to conduct investigations. Typically, the language is conduct an investigation that's appropriate in the circumstances. The law is nowhere near as prescriptive as it is as what we've seen with Bill C-65. But I think that there's sufficient case law. I think that there's sufficient guidance from provincial regulators to set out an expectation for provincially regulated employers as well, that a workplace harassment investigation does have to be treated seriously, acted upon promptly, given sufficient time, given sufficient resources, and really that anyone conducting an investigation has to be provided with the appropriate training, education, and experience to do so. So we'll jump to the next slide. Just got some final thoughts here on the investigative process that are set out in the regulations. First of all, if there is no predetermined list of investigators, or if there is no mutual agreement on who an investigator should be, then the regulations say that if that doesn't occur within 60 days of that notice of investigation being provided by the employer to the parties, then a person identified by the Canadian Centre for Occupational Health and Safety, the CCOHS, as they're known, may be selected as the investigator. And the CCOHS on its website maintains a roster of investigators. I think the last time I checked, there was about 75 of them. Names, contact information, locations that they deal with, areas of expertise, and so on is all on the website. In terms of the investigator's report, once the investigation is complete, the employer receives a copy of the report from the investigator, has to provide it to the principal party, the responding party, and the Workplace Health and Safety Committee. So as a result of that, the investigator's report must not reveal, either directly or indirectly, the identity of any persons who are involved in an occurrence or the resolution process. It would contain recommendations for things like training, for example, but it cannot reveal the identity of those involved. Under the regulations, the resolution process is considered complete once the employer implements the recommendations in the investigator's report, and the employer is required to reasonably attempt to come to an agreement with the workplace committee regarding which recommendations are to be implemented. Ultimately, if there is a discrepancy, the employer's decision would prevail, and workers would still be entitled to follow the internal complaint resolution process in the code, basically the equivalent of the work refusal process in many provincial statutes, or file a grievance or file a complaint under the Canadian Human Rights Act if they felt that an employer's decision not to implement a recommendation in an investigator's report was perhaps a failure to protect their health and safety. And then finally, there is no appeal process under the code or regulations if a party isn't satisfied with the conclusions or recommendations in the investigator's report or believes that the investigation was flawed in some way. So that's a bit of an update from the federal sector. I'm going to pass it over to Rebecca now to continue on.
Thank you, Cathy, for providing that federal update. So in this section, I will now address some recent case law developments. And I think we would all agree and acknowledge that statutes and case law often lag behind developing social discussions, movements, and understandings. And this is in part due to the fact that once a complaint or a claim is made, it does often take some time for that matter to lead to a published decision. And so while we are seeing some shifts in the way that courts and adjudicators are understanding social issues, and we will discuss some examples in a few moments, we do want to highlight the fact that, and as the slide says perfectly, dated precedents are just that. And what I mean by this is if you are reviewing case law, especially in the areas of discrimination, racial discrimination, sexual harassment, or sexual assault, and so on, the precedents that you may come across may be completely outdated. And this is often because law can be slow to change. And it has taken courts some time to fully realize the impacts of social justice and social movements and the tangible experiences of employees in the workplace. And therefore, often we find that legal tests and standards may not align with current awareness. And there was a 2019 Court of Appeal case out of Alberta that discussed this. It was called Calgary City and Canadian Union of Public Employees, Local 37. And it had discussed an arbitrator's reliance on some outdated precedents in a termination case which dealt with sexual assault. And in that case, the court stated that arbitrators must consider whether time and changing social values reveal precedents to be based on faulty assumptions. And in that case, the Court of Appeal found that the arbitrator's reliance on two outdated precedents related to sexual assault made the arbitral award unreasonable. And so therefore, we must refrain to the extent possible from referring to outdated legal ideals and societal myths to dictate our responses to current situations, including in our investigations, or else our actions may be subject to scrutiny. And as lawyers and management professionals, while we do want to be mindful of and should read cases, we must also be aware that things move quickly, and it is our responsibility not only to keep in mind the relevant case law, but also relevant social movements as well. However, there have been some important legal updates which demonstrate law's ability and potential to catch up to culture, and we will discuss those on the next slide. So the first case that we wanted to highlight is a decision from the Ontario Human Rights Tribunal, which concerned a complaint made by 3 employees who had identified as either genderqueer or non-binary and used they, them pronouns. So the employees in this decision alleged that the owner of the bar and lounge they work for had refused to use their correct pronouns as instructed by them and instead had misgendered them. So to provide an example in the evidence, the employees stated that in response to a request, to their request that they be referred to by their correct pronouns, the owner stated that he believed that he had to walk on eggshells around them, implying that their request to be referred to by the correct pronouns meant that they were too sensitive. So the employees also alleged that they overheard that same owner talking to customers on the dining room floor about them and had used a transphobic slur to refer to them. And when the employees had raised a concern about the use of this slur, the owner denied it and refused to address the employees' concerns about his use of pronouns. So the 3 employees eventually quit their employment. They felt that their dignity, safety, and privacy was not being taken seriously, and they filed this human rights complaint against the restaurant and the owner. And it's important to note that neither responded to the applications, and the allegations were therefore deemed by the tribunal to have been accepted. And next slide. So the tribunal awarded each employee $10,000 for compensation for injury to dignity, feelings, and self-respect. And in coming to this award, the tribunal made various findings, which are listed on this slide, but the most important of which includes that misgendering or the use of incorrect pronouns amounted to adverse treatment with respect to employees' employment at the bar and lounge. And this final finding is an important one because while in earlier cases, the case law has addressed the lived experiences of LGBTQ persons in the workplace, the tribunal is now clear that acts of intentional misgendering and incorrect pronoun usage can constitute adverse treatment and can amount to discrimination. And this does represent a shift in the case law, since it signifies that there must be respect for the pronouns that an individual uses and has asked to be used in the workplace, and that failure to respect such pronouns intentionally can amount to discrimination. So we'll now move to the next case. And the next case I want to address is similar in nature to the first case, Gallaghers Bar and Lounge. So this case, Goodberry Restaurant Group, deals with an individual complaint, this time to the British Columbia Human Rights Tribunal. And in this case, the complainant was a server for the restaurant respondent and identified as a non-binary, gender fluid, transgender person who used they, them pronouns. During their employment, the bar manager at the restaurant, who was also a name respondent, persistently referred to the complainant with she, her pronouns and with gendered nicknames such as sweetheart and honey. The complainant repeatedly asked the bar manager to stop using female pronouns and the gendered nicknames, but the conduct did not stop. So the employer at this workplace had a harassment and inclusion policy, and the employee eventually brought their concerns about the bar manager's conduct to management's attention. And while management did initially speak to the bar manager and instructed him to be accommodating and use the correct pronouns, the conduct persisted, and the complainant was asked to wait for further intervention from management. Unfortunately, the conduct persisted, and the complainant was ultimately terminated after their attempt to address this conduct with the bar manager led to a heated encounter. And pressed to explain the termination, the employer had advised the complainant that they had simply come on too strong. Next slide, please. So the British Columbia Human Rights Tribunal concluded in this decision that there was a clear connection between the complainant's gender identity and their termination. So the tribunal found that the complainant was terminated because of how they responded to discrimination. And the tribunal made an important connection between the employer's act of terminating the complainant and what it calls the well-known propensity to label persons who speak up about discrimination as problematic or difficult to deal with. And the tribunal found that by its actions, the employer had perpetuated the discrimination by terminating the complainant instead of trying to make efforts to investigate and resolve the conflict between the complainant and the bar manager. Ultimately, the tribunal found that the employer had discriminated against the complainant and awarded the complainant a global award of $30,000 in damages, which it was responsible for. And I think there's two main important takeaways from this decision. And the first is, again, this shift in law towards respect for using the correct pronouns, which kind of brings the law more in line with current social values. So the tribunal makes an important point in its decision. It says, like a name, pronouns are a fundamental part of a person's identity, and that using correct pronouns communicates that we see and respect a person for who they are. And they say, especially for trans, non-binary, and other non-cisgender people, using the correct pronouns validates and affirms that they are a person equally deserving of respect and dignity. And I think that this decision underscores the obligation of employers and management personnel to respect employees' gender identities and expression. And that obligation includes ensuring that the correct pronouns and names are used in the workplace by all employees and management personnel. And importantly, the tribunal framed this obligation as a basic right and not an accommodation in the workplace. And I think the second takeaway from this decision is that it's an important reminder to employers that reports of discrimination and harassment in the workplace must be taken seriously. And so while the employer in this decision did take some steps to address the discrimination once it was made aware of it, when discrimination persists, it is not reasonable to allow employees to endure discrimination until the employer finds an appropriate time to respond. So in this case, the complainer was told, kind of wait and see. The employer must respond with a sense of urgency once it is made aware of a complaint. So we will now turn to the next slide. Thank you. And the final decision I want to discuss is a recent decision out of the Alberta Human Rights Tribunal, which deals with the tribunal's consideration of the relevance of shop talk as a defense to allegations of sexual harassment. So in this case, the complainant was the only female laborer working at the employer's construction site. So it was a male-dominated workplace. And on several occasions, the complainant's supervisor made various sexual comments and or asked sexually charged questions to the complainant. And so the complainant made a formal complaint about her supervisor's behavior to the employer. However, the respondent did not fully investigate the matter. And in evidence, there are various facts about the failure of the employer's investigation into the behavior of the supervisor. The complainant eventually made this complaint to the tribunal, and she alleged that her direct supervisor had sexually harassed her in the workplace, among other allegations which are listed on the slide. So we'll turn to the next slide. And in this case, the tribunal ultimately found that sexual harassment did occur and awarded the complainant general damages of $20,000. And in reaching its determination with respect to sexual harassment, the tribunal was particularly critical about the employer's shop talk defense, which we've seen before employers in industrial settings have sometimes used in the case law to excuse unwanted sexual comments on the basis of industry culture. And in rejecting this argument, I want to highlight the statement that was made by the tribunal, paragraph 50 of the decision, which is on the slide. And it says, importantly, the very implication that sexual harassment is not sexual harassment because of the type of work location belies the fundamental principles of human rights in our province. And it says, although some work sites may have norms that are unacceptable elsewhere, that does not mean that we can ignore an objective baseline of appropriate behavior that is expected. And the tribunal further noted in its decision that human rights legislation applies regardless of workplace setting, and issued a strong warning to employers that if the shop talk of the worksite permits sexual harassment as a norm, then the employer has a human rights responsibility to change the norms. Otherwise, a respondent employer is responsible and liable for the acts of sexual harassment committed by an employee. And I think the importance of this case is that it is a cautionary tale to employers that the defense of shop talk will not excuse behavior that is contrary to baseline expectations for workplace behavior, regardless of so-called workplace norms or culture. Instead, the tribunal outlines that an employer has the responsibility to change those norms of the workplace, or to ensure that workplace culture is respectful of human rights norms. And the case also warns that employers must carefully review complaints of harassment, regardless of the work location or norms, and conduct proper workplace investigations that are compliant with its workplace policies, applicable human rights legislation, in addition to health and safety legislation. And that concludes the case law updates for today. With that, I will now pass the mic over to Katherine.
Thanks very much, Rebecca. And I look forward to the day where we can actually pass the mic. Hopefully next year, everybody. Thanks, Rebecca. Those three cases are super important in that they bring us all up to speed on where the jurisprudence is. And it's good to remember that as lawyers and HR professionals, we need to rely on the law as it comes to us through reported cases to tell us what are the standards of behavior. But as Rebecca noted, and we talked about this last year as well, the case law can lag behind because oftentimes what is complained of happened a number of years ago, and it takes a number of years to wend its way through the system, so that by the time the adjudicator or the court is finally opining on something, society has already moved along. So case law is important, and we need to keep reading it and refresh ourselves. And as investigators, we know that we are on the front lines of behavioral norms, societal changes. So that's why we wanted to shift gears a little bit and talk about intersectionality, which, as I indicated at the beginning in the intro, is kind of a buzzword for 2022. It's something that we want to bring to the table here today to add a bit of value to for your takeaway, and that really is this concept that investigators have to be sensitive to intersectionality, and by that we mean an analytical framework where we understand the ways in which there can be layered forms of discrimination or bias held against one person who has overlapping identities, overlapping experiences, intersecting and leading to perhaps discrimination or sometimes privilege. The next slide will indicate common or main grounds of intersectionality: gender, sex, gender identity, race, sexual orientation, and so on. So that's what we're talking about when we're talking about intersectionality. What we mean about it, and next slide, please, in the context of investigations, is something that we have observed, and this has been talked about quite a bit in 2021, 2022, that as investigators, most of us are trained or just come to it naturally. It's the way our brain is wired to categorize and simplify complex issues. And so that we focus in a singular way on one item, on a singular form of discrimination, even if what is right in front of us is in fact multiple issues. So the point that we would like to make today is to be mindful of specific indications of intersectionality and to consider the nuances that this brings to a complaint. And by that, I mean, regardless of how a complaint is framed at intake, an investigator should pay close attention to how the complainant frames the issues underlying the complaint. So you have to be sensitive, you must listen carefully, at what the allegations are. And so an individual may come forward who is, for example, a gay man of color who complains that he is being discriminated against because he is gay. The way he is framing the argument or framing the complaint is singular. And we might just focus on this is a case about a gay man. And we might miss the other important element in the intersectionality, which is that he is also a gay man of color. And so what we are asking investigators to do when a workplace complaint is made, next slide, please, is to not just be mindful, but to consider the following so that we can identify issues of intersectionality during the investigation process. So how is the complaint defined by the employee himself or herself? But more importantly and more broadly, how does the employee describe themselves and what is happening? How does the employee describe the reason for the complaint? Listen carefully, listen with sensitivity. And we think an example might assist us in that regard. We have in our example a Black factory worker who identifies as female, and she makes a complaint that her supervisor has it in against her because of her race. She also alleges that she's treated differently than her Caucasian male coworkers, that when opportunities arose in her area, her supervisor ignored her and promoted her male colleagues instead. So our brain is telling us, focus in on what this worker is complaining of, which is that she's been discriminated against on the basis of her race, and we're off to the races in terms of just focusing in on race. If we look at the questions that I mentioned in the preceding slide, though, what we're asking investigators to do is just say, pause for a moment and see what else might be going on here. It's important how the complainant herself frames the issue, but it's also important to expand that and to say, okay, what is she describing? What are the reasons for her complaint? Next slide, please. And I think in doing that analysis, you come to the realization that what this individual is complaining about is not just race, but also gender. Not just gender, but also race. And in going ahead with the investigation, the impact of that intersectionality, where race and gender meets, combines, it's layered on, that is where intersectionality and investigations is today. And it may seem in a way common sense, but it's worth reminding everybody to be very aware and sensitive. A couple of issues that are common pitfalls in investigations and as they connect with intersectionality that we wanted to highlight as well. And just what we're asking people to do is just not to fall into a trap in a way that if we're investigating something and the respondent shares an aspect of identity with the complainant, for example, Carol is a Black woman, she's brought a complaint against Sally, a white woman, they're both women, and so therefore there can't be any gender issues. We're just asking people to be, investigators to be more nuanced in their approach and to say, wait a minute, just because both are of the same gender doesn't mean that there can't be some gender bias or some discrimination going on. Another common pitfall that we wanted to identify, next slide please, is where a complaint is made and it's clear that other members of a group are not treated the same as the complainant. And I have to say it used to historically be, well, if no one else is treated the same way, then the conclusion we come to as investigators is the individual who has complained, there's no substance for that. The nuance and our emphasis on intersectionality and being mindful about it tells us it may be the case that it's an important factor, but don't jump to the conclusion that just because other members of the group are not treated in that way, that therefore our complainant could not possibly have been. It's not necessarily the case. And what we're truly asking folks to do is just to check their bias, jump into conclusions at the door, do a deeper dive on what's really going on here, and to avoid those common pitfalls. So that's sort of the whole issue with intersectionality. And just a reminder in 2022 that there's an expectation of investigators that you look at all of the layers of a person's identity and make sure that that the investigation that you're conducting is truly connecting on each of those points. Just also, it's in 2022, and just carrying on the conversation from a year ago, and looking at the next slide, please. What we're, sorry, I'm, I think, missing a couple of slides there. I'll move that over there. Okay, how to address historic allegations. I'm also going to look at addressing anonymous allegations. And all of this has come to the fore, and we talked about it quite a bit last year when we knew that with Me Too movements, Time's Up, we saw Harvey Weinstein dragged before the media. Thank you. That was the slide I was looking for. Times Person of the Year were women who were coming forward with complaints against people in positions of power. And since then, in the last year, we've seen many more examples. Governor Andrew Cuomo of the state of New York, for example, was subjected to some allegations of sexual harassment and had to resign as governor of the state of New York. We know in the RCMP and the Canadian military that there are many, many cases of women in particular coming forward and alleging sexual harassment, sexual misconduct, sexual assault, that all of the publicity of these movements and all of the publicity that we see in our headlines, we can see a correlation between what's in the news and people in your workplaces putting up their hand to make complaints about serious matters, and not just matters that have recently occurred, but we know that people are encouraged by what they read in the media to come forward to make complaints. And so I just noticed today before we started this presentation that Prince Andrew has agreed to settle with a woman who, when she was 17, which was 20 years ago, alleges that Prince Andrew sexually assaulted and molested her, and he settled that. That kind of publicity, we know, resonates with people in workplaces who either remember or understand that it's open to them as well to make complaints. So a couple of issues arise in that context. And one is addressing historic allegations in workplaces. It's the preference of law, for sure, that when you have a complaint about something that's gone wrong in the workplace, that you put up your hand right away and make a complaint about it right away. There's good reasons for that. People's memories are fresh. The context is clear. And so there's a strong preference. And in fact, we see statutes of limitation where there are limitation periods on when complaints can be made. Those limitation periods, though, do not apply to historic allegations that are connected in any way to sexual harassment or sexual assault. In part, that has arisen because people have realized that people who have been the victims of assault or harassment have had good reason to bury it and to not come forward with allegations. But in light of where we are in society in 2021, 2022, with lots of press about people coming forward, to make allegations, it leaves employers with historic allegations and factors to consider. When I started practicing law, and even in the last 10 or 15 years, if something was an old allegation, many employers, and I would advise employers in this regard, because that was the state of the law at the time, you don't have to deal with it. Too much time has passed, unfortunately. That's not the case any longer. We know that Bill 132, now part of Ontario's Occupational Health and Safety Act, requires employers to investigate incidents, and there's not parameters around that. And it's also in the best interest of the employer in any event to address historic allegations. But we know that there are issues with historic allegations, particularly very, very aged allegations. So what do I mean by historic? I mean, I think there's a difference between 2 years and 20 years. And I also think, one issue is how long ago are we talking about? One of the issues that arises with historic allegations is the availability of evidence. We know that memories do not get better with age, rarely so anyways. We know that in places of employment, people who may have been witnesses are often long gone and not traceable, so that's a problem. We know that often in cases that are historic, the documents are destroyed, and so we're left with kind of not great evidence. That's not a reason not to proceed, but it's an issue with historic allegations. The seriousness of the allegations, I think if you've got a case that's 20 years old and is an inappropriate joke told at a holiday party 20 years ago, I look at that differently than if somebody comes forward to say, 15 years ago, I was sexually assaulted at a holiday party. The seriousness of the allegations are going to make the employer think about how do I want to attack that. I think if there's a serious historic allegation or an allegation about systemic problems, that you've got to investigate it regardless of how long ago it is. And there's also the complainant's wishes. So you have to, those are issues with historic allegations. I think the main point that I want to make in 2022 is you can't just not deal with historic allegations on the basis that it's too long ago and who remembers. You've got to roll up your sleeves, look at all of these factors that I've suggested, and then put a plan in place to investigate it to the best extent that you can. Linked to addressing historic allegations is the next piece that I want to touch on, which is connected in a way, and these are anonymous complaints. We asked, when we had everybody sign up for today's session, we asked people when they signed up to provide us with any questions that they had, and we put them on an Excel spreadsheet, and we read them all, and we try to build them into our presentation. We had a number of questions come in that asked us about anonymous complaints. I referenced when I started and how we used to deal with historic complaints. It used to be the same with anonymous complaints. If it was anonymous, we didn't deal with it. There was too many potential issues with anonymous. Usually, we would worry about, as an employer, well, if we don't know who it is, somebody with a bone to pick could put up his or her hand and make a complaint, and how will we ever know? And it might take somebody's reputation down in flames, and that's surely not fair. We've come a long way since that approach, and I think it's the case that most employers will absolutely investigate anonymous complaints. They'll have a whistleblower policy that encourages people to come forward. And that's really the benefit of allowing anonymous complaints in the workplace. It encourages people to come forward with complaints. And that's the way, as an employer, that you root out what might be bad or what might be rotten in your place of employment. You want people to come forward. And sometimes the only way they'll come forward is through anonymous complaints. We also know through legislation that there is an obligation to investigate incidents. And so if you become aware of a complaint, even if it's anonymous, you've got to roll up your sleeves and decide how you're going to deal with it. How are you going to handle it? And what steps can you take to protect a complainant's anonymity if you can? I mean, really, I think when an anonymous complaint comes in, it depends where it comes in from. I've been involved in a number of whistleblower complaints where somebody's called and reported, and unfortunately, the person on the receiving end is not, asked great questions, and it's hard to tell what the complaint is about. So in a way, garbage in, not garbage out, but it's not going to be the world's best investigation. The more facts, the better it can be. And the more, as an employer, you can zero in on what is the complaint? Where is it? How do we get in? Do we know the location? Can we focus on the department or the area? Sometimes it may become completely clear who is the complainant. And in that case, you've got a bit of an issue because you don't want the complainant to feel that his or her anonymity is going to be sacrificed. So you want to always express how important confidentiality is. Next slide, just a couple of do's and don'ts with anonymous complaints. You can't really, you have to do the best that you can, and you have to try to conclude your investigation within a reasonable time frame. You have to deal with the facts as they are alleged and do the best that you can, as I've said. You want to go in and interview if it's clear who may have information, you want to find out and get as much additional information as is possible. In other words, you cannot just close your eyes and hope that it all goes away. You've got to tackle this to the best that you can. So you don't want to dismiss complaints outright simply because somebody is anonymous. You don't want to make assumptions ever about any complaint, whether anonymous or otherwise, right? If this is anonymous, it can't be, it can't be that strong. Or opposite, if somebody's complaining about their manager, there must be where there's smoke, there's fire. Just do not make those sorts of assumptions. And as well, and always, you want to keep your investigation of this anonymous complaint as confidential, not just anonymous complaints, any complaint. You have to keep it confidential. Sometimes at the end of the day with an anonymous complaint, I've certainly been involved with anonymous complaints where you really can't quite sort out what's happened, but it doesn't mean that you throw up your hands, in my view, and just say, oh, well, we tried. Sometimes what you might decide is that there's enough there that we might want to bring somebody in to conduct a workplace review, or we might want to do an employee survey so that we're asking our employees and trying to get at what's going on there. And you can find out through a survey or through a workplace review, or you just encourage your managers to walk around a bit more when we're back in the office or back on the plant floor, that is, and manage by walking around, put the ear to the ground, and so on. And so just to conclude on the point about anonymous complaints, that's a change. Same with historic complaints. You have to take both seriously. I'm going to pass it over to Sarah, who's been waiting patiently. Thank you, Sarah, who's going to continue on with our advice on the continuing importance of procedural fairness. Sarah, over to you.
Thanks very much, Catherine. As we discussed in that first session, if you attended back in May of 2021, it's important to remember that while we want to make sure that our investigations and our workplace culture reflect current understanding and developments and values, we still have to ensure that we comply with the requirements of procedural fairness. It's essential that the investigation and the process that we follow be perceived by all parties as being fair and unbiased. And that is both the respondent and the complainant. And as Katherine just mentioned, we want to make sure we have systems and policies in place that are seen to be fair so employees use them, because that's the way we learn about issues at the earliest possible time, and we have the best chance to resolve them before they turn into really nasty problems, and maybe we can avoid litigation. This slide contains some of the common errors in workplace investigations, and it actually came out of a recent Saskatchewan Queen's Bench decision from 2020, where they summarized some of these key issues. This case involved the principal of a school who was demoted. The issues involved a conflict of interest and bullying of parents and students on a volleyball trip, of all things. But he was demoted at the conclusion of an investigation that had been conducted by the school board. And actually, the case is called Oberg, O-B-E-R-G. And at paragraph 37 of that case, they actually listed a survey of decisions where across the country where mistakes were made that led to a violation of rules of procedural fairness, which were found to be failures to act in good faith. So we thought it was an interesting decision to discuss. So the first one deals with rushing to judgment before you obtain the facts. Now, this can be related to perhaps a bias or an unconscious bias. In our last session, we talked about confirmation bias, where we have a tendency to look for or emphasize facts that confirm an impression we already have. So we need to be mindful about that. It's also important to remember your role as an investigator is one of being an independent fact finder. There is a difference between an allegation and a substantiated allegation. So there may be a lot of pressure to act on an allegation, but as an investigator, you cannot assume that that allegation is true, because making that determination is actually your very mandate. And as we talked about last time, the fact that we are re-examining a lot of underlying assumptions, for example, in sexual harassment cases, doesn't mean that when conducting investigations, we don't ask the questions. We just need to be mindful about how we ask the questions and think about how we gather evidence. But we'll talk about that in a few minutes. So when the other if you look at the second point to maybe the fifth point on this list, they all deal with issues about giving information to the respondent. So we want to ensure that the respondent understands what the allegations are that they're being asked to address, that when we get that employee's response, we are actually considering it. We're putting relevant evidence to witnesses to get their response. We're really ensuring procedural fairness such that the person who is accused of the wrongdoing has the opportunity to provide their response, and that we consider that response, and we're not in any way being misleading. The other failure that was noted in this decision was failing to consider other evidence. So just dealing with the interviews of both parties and not thinking about other sources of evidence that could help with the investigation. So, think about asking for things like documents, posts that may have been involved, texts. Are there other kind of records that you could pull, or other evidence that you could collect that would be relevant to the investigation? Next slide, please. So if there's a flawed investigation, if it's considered unfair, what are the consequences? So those findings, regardless of or whether you think they're correct or not, they can be deemed inadequate by a court or by a tribunal. And if that happens, or an agency, then various things can happen. One, you can set aside the sanctions that were imposed by the employer. So where we see that is where a dismissal for cause is not upheld, because the investigation establishing the wrongdoing that was the basis of the cause termination was found to be flawed. There can be an order that the investigation has to be redone at the cost to the employer. We've seen in Ontario, the Ministry of Labor can come in as a result of a complaint, for example, by an employee, and order an investigation take place by a third party at the cost to the employer. So we want to ensure that our investigations are procedurally fair. And then, of course, there can be a variety of damages that can be ordered in court actions or tribunal actions to compensate that investigated employee for things like lost wages, mental distress, loss of reputation, those types of damages. Also, we have seen too, where an investigative process is flawed, where there's a feeling that the respondent is not going to be given a fair shake and may just be terminated, that can provide a fertile ground for union organizing efforts as well. Because a union can easily say, were we involved in that workplace, there would be procedural fairness. You would have a union representative with you, perhaps, those types of things. So it's also important to keep in mind from a labor relations strategy. Next slide, please. So on this topic, I just want to leave you with a few points before we move to the next topic of discussion. Know and follow your investigation policy and procedure. I've been involved in many cases where companies have excellent policies, but there isn't training on them, or a person who's called in to do an investigation on very short notice when they're very busy may not be aware of all the nuances and the requirements of a particular policy. So it's important that if you have those great policies and that the key people are trained on what they include. The investigator you select has to be a good listener, and by that I mean an active listener, someone who is watching the responses of the person that they're interviewing and being sensitive to what they are seeing, picking up cues of other areas to pursue in the interview, for example. You want to make sure you get a clear understanding of what's happened before, during, and after a particular incident and not be too narrow in your questions. And as I've said repeatedly, giving the respondent the opportunity to respond and notice of the allegations is key. We want to make sure that, especially when you are interviewing a respondent, but witnesses as well, that you advise people about the policy against reprisals, that there is no toleration for any kind of retaliation or reprisal against someone for bringing forward a good faith complaint. There are many cases where, for example, an underlying claim of discrimination is found not to be substantiated in a court case, for example, but the reprisal that took place because the complaint was filed has been substantiated. So a company can have to be required to pay damages for a reprisal, even if the underlying discrimination has not occurred. So it's very important to make sure that all parties understand that reprisals are not permitted, and that we advise complainants that if they have any concern at all that they're being reprised against or being treated differently because they've brought up these complaints, that they come back to us right away so that we can address it. And again, it's essential that we be perceived by all parties as being fair and unbiased. Next slide, please. Okay, so let's switch gears for a minute and talk about conducting investigations in a sensitive manner and considering lived experience. One of the things that we thought would be very useful to talk about today is something that we're hearing a lot about lately, and that is a trauma-informed approach to investigations. And frankly, it's something that makes people very uncomfortable. It makes many investigators feel uncomfortable because they think, I'm not a psychologist, I don't understand how to do this. And so we wanted to go over some basic concepts and give you some practical tips and an approach that you could apply, especially when you're dealing with issues that involve, assault or, for example, serious sexual or racial harassment. A definition that I found helpful that we found recently when we're talking about a trauma-informed approach is it's a way of interacting with people in a professional capacity that recognizes that they may have been impacted by trauma. So, as Katherine spoke about, we're dealing in this presentation with social movements. And social movements tend to arise in response to shared trauma. And we saw that the Me Too movement really opened this unprecedented discussion about the realities of sexual violence and trauma that people had experienced in many workplaces over many years. We all should be aware that social movements can bring up issues of trauma for people as well. So, for example, the coverage of George Floyd's death and other instances of racial injustice and systemic racism, listening to that was traumatic for many, and dealing with that reality. And then recently, where residential school survivors talked about how they felt re-traumatized and had renewed trauma following remains of, the discovery of the remains of children near residential schools. And so I think it's very important just to be cognizant of the fact that trauma plays a role in many people's lives. Next slide. But as I mentioned, addressing this topic can kind of be overwhelming and a bit intimidating. But I think it's important to remember that we are not psychologists. We are not clinicians. We're lawyers. We're HR professionals. We have different roles and different objectives. A psychologist is there to provide support, for example. We are there to do fact finding. We also have very different training. And we're not asking investigators to be psychologists or to be clinicians. What we're suggesting is using this approach is a way to make your investigation more sensitive and possibly help you get the best information in difficult circumstances. So as I said, our job is basically fact-finding. We're there to determine what happened, and depending on our mandate, determine whether there's a breach of a rule or policy or law, whether that's occurred. And the key thing is how we conduct ourselves in our interactions with all the parties has a direct impact on the information we receive. What we want to do is get the maximum amount of information without causing unnecessary discomfort for people. We want to get the best quality information we can, and we want the processes that we follow to contribute to organizational trust so that people trust their organization's policies and the processes that will be followed. So if we go to the next slide and we take a step back, we can look at what does trauma mean. It's a term that's used to describe the challenging emotional consequences that living through a distressing event can have for an individual. And as we can imagine, it differs from person to person. So it can be a result of a recent single traumatic event, a traumatic event that occurred in the past, or a long-term chronic pattern, so where we have sexual or physical abuse. And the trauma can lead to, and the experiencing of the event can lead to post-traumatic stress disorder or PTSD, which can really seriously disrupt a person's ability to regulate their emotions and deal with stressful situations and maintain relationships. Next slide, please. So trauma can have long-lasting impacts on individuals, and it's fair to say that individuals don't leave particular trauma at home when they come to the workplace. But what's key for us to remember is trauma can also arise at the workplace. So where there have been incidents of workplace violence or bullying or serious sexual harassment or racial harassment or assault. And in today's workplace, that can include an employee's home, maybe not for the long term, but at least in the moment. A lot of people are working from home, and we're expecting a lot of employers to have hybrid operations going forward. So this idea of the workplace is expanding as well. So trauma and the impact it has on individuals is relevant to our ability to carry out an investigation in a procedurally fair manner and in a sensitive manner. Next slide, please. So there's two ways that trauma can impact our investigation, two main ways. The first thing is that trauma can affect a person's behavior and how they react to and deal with the issues surrounding the complaint and the investigation. So they may react in ways that you as an investigator are not used to seeing, or ways that you don't expect, or ways that you may not respond if you were questioned about your conduct, for example. So we need to be mindful of that as we reach conclusions, or if we have a tendency to reach conclusions based on their behavior. I'm not saying we cannot reach conclusions based on the way someone acts during an investigation, but we should at least consider the possibility, as Katherine talked about when she was talking about intersectionality, just broaden the way you think and think about other possible alternatives before we reach a conclusion. The second way it impacts is it affects memory. Now, this is something that is still being studied, the impact of trauma on memory, but I think it is established that there is an impact. Typically, most people can give a detailed, chronological report of something that happened, and they can talk about what happened and when and give you some details. But a key thing to remember is remembering always involves reconstruction, even when trauma isn't involved. So we're always reconstructing when we're remembering. And trauma can impact the way people remember things. So we can deal with fragmented memories, memory gaps, inconsistencies in someone's report. One thing I thought was interesting in some of the work I've been reading on this topic is that during a particular traumatic event, someone may focus clearly, be hyper-focused on something that was important to them at the moment. And they can remember and report on that clearly. But things that they perceived peripheral at the time, they either don't remember or can't tell you about them in any detail. And what's important to just be mindful of is that what we as investigators may see as significant versus peripheral may be very different from the person that we're interviewing. Next slide, please. So this quote I thought was useful as it just reminds us to avoid making snap judgments when we're dealing with issues of memory and possible trauma. And I'll let you read that. This is in the context of a sexual assault and jumping to conclusions that people are lying if they can't remember every detail of an incident in a chronological fashion. Next slide, please. This is a case that I thought was important to bring up because it illustrates the very point I'm just making about the impact of trauma on memory. And it shows that judges are actually recognizing that this is something that occurs. And in this case, many of you may have seen this or remember this one. There was an employee who suffered sexual harassment for many, many years. It was an employee who had a background of abuse. The employer knew of their particular vulnerability. They actually lived, above the shop, and the employer was also the landlord. And after looking at this case in some detail, the vice chair at the tribunal awarded $200,000 to the applicant who had endured this sexual harassment, sexual abuse, and sexual assault at the hands of this employer. And the respondent here applied for a judicial review of the decision, basically saying that the vice chair's approach was procedurally unfair and challenged the decision as being unreasonable. Next slide, please. One of the things they pointed to was that during the retelling of the event, there were things the person could not remember. There were inconsistencies on individual pieces of evidence. And the fact that these weren't given more credit to discredit the complainant was the subject of this application for judicial review. And here, the court found that even though the applicant had gaps in memory and inconsistencies in the evidence, these were not signs that she was telling a false story. And the quote is here: "Given Ms. B's memory issues, inconsistency in her evidence took on less significance as a test of her truthfulness than they might in the case of a witness who was not suffering from such issues." So here, the court recognized that this traumatic experience, in this case of sexual assault, could affect the way the individual behaved and retold their story. Now, interestingly enough, in this case, there was medical evidence to support the fact that because of PTSD, she had memory issues. But it really stands for the proposition that courts will address issues of memory loss differently when trauma is involved. And so we, as investigators, need to be mindful of this as well. Next slide, please. So a trauma-informed approach includes an understanding of the physical, social, and emotional impact of trauma on individuals. It makes, what we have to do is realize the prevalence of trauma, recognize how it impacts individuals, integrate that knowledge into our practice, and then actively try to avoid re-traumatizing people. Next slide. The good thing is, though, that there are small changes you can make to what you're already doing, how you ask questions, how you interview, that reflect this trauma-informed approach. And if you more consciously do what you're probably already doing, you're also going to be using a trauma-informed approach. You know, things we already do, like we build rapport, we explain our role and the process that's going to take place. We use active listening skills. So we see when people are overwhelmed and distressed and we take a break. And we make sure we ask neutral and non-leading questions. Those things that many of us are already doing as best practices and investigations are part of this approach. So what can you do? In your pre-interview approach, making sure the person feels safe is very important. Very often, contact them by email first and ask them to contact you to set up a time so that they feel that they have some control. Make sure you're in a private, comfortable, neutral place, a place where they're not going to run into the respondent. If it's going to be done at home, ask them if it's a place where it can be done privately and they feel comfortable if we're doing it by Zoom. Make sure they have water. Make sure they have something to drink. For the purpose of, drinking actually makes a person breathe when they're doing it. So if someone's anxious, giving them a drink will help. Be transparent and build rapport. Provide them a roadmap about what's going to happen and the timelines, especially where you're going to be dealing with difficult territory. So if you're going into the follow-up meeting where you're going back to the complainant to put to them information that is been brought up by the respondent, tell them what you're going to be doing. Tell them that that's the purpose of the interview so that they have some warning. And I want to just highlight the difference between empathy and bias. It's biased if you say, I believe this allegation before the investigation is completed. If you say things like, I'm so sorry this happened to you, I will make sure it never happens again, or this was a terrible thing you went through, that's showing that you're prejudging and can suggest bias. What we're talking about is building rapport. So saying things like, I can see this is difficult for you to talk about. You can see the difference there. Next slide. So ask trauma-informed questions. So in previous seminars, we've talked about, you ask a general question, what happened, and then you drill down in the W5 to get all the details. Here, say things like start where you feel comfortable, start at the beginning, tell me what you remember. Things like what else happened or what else do you remember, as opposed to what happened next, things like that. Be neutral. So when you don't understand something, say, can you help me understand blank, as opposed to being accusatory. And then Empower the person who is being interviewed. Have I missed anything you would like to add? And then after you've got that narrative and you've exhausted it, you can go back and fill in the gaps using that W5 technique, the who, what, where, when, and why. And think about limiting the duration of the interview, getting a language interpreter perhaps if you need it, and consider a support person. But again, you would set the parameters for the support person's participation. Next slide, please. What we want to avoid in a trauma-informed investigation is judgment and victim blaming. So we don't want things like, what were you wearing? What did you do to encourage it? What did you do to fight back? Why didn't you yell for help? Things like that. Those are the types of questions or comments that can reinforce myths or misperceptions. And think about, bias, making sure you're objective. Take off your HR hat, as we often say, and think about your own background and if there are any things in your own past that will cause you to respond particularly in a particular way and maybe a biased manner. And avoid implicit or unnecessary repetition. So if someone is asked to tell their story over and over again, it can actually re-traumatize them. So be mindful of that when you're planning. Next slide, please. It's very important how you close the interview because you want to maintain that rapport. I talked before about empathy. I understand that this may have been difficult for you to discuss. Thank you for participating. Leave room for follow-up. Tell them they can come back to you if there's something else that occurs to them later. And make sure you have, before you start the interview, you understand what resources are available for them, like EAP, and that you can tell them about that and share that with them. Next slide, please. So just a few closing thoughts, and then we'll move to questions. It's important to recognize that social movements and their impact, and that the evolution in our thinking and discussions about people's lived experiences are really having an impact in the workplace. As all of our speakers have talked about, the laws is evolving, and employers have to stay abreast of those developments. Read about things like intersectionality, trauma-informed approaches. Keep yourself informed. Prepare for increased scrutiny of your investigations. There's some tips listed here on this slide. Remember, the hallmark of a good investigation is a really good file that you can produce 2 years from now if you're called on to do it. Next slide. Keep in mind procedural fairness, and that's for both parties, both the respondent and the complainant. You still have to ask the tough questions. Just think about how you're going to do it. Ensure you have policies, educate yourself, and be mindful of stereotypes or own biases creeping into investigations. So that's a bit of a gallop through, a complicated topic. But we'll now take some time to answer your questions. We've had a number of good questions come in, and we had some before as well. This is an interesting question. This question is for Cathy, and it's a discussion about the risk assessment. So let's see. It basically says, what advice would you have about conducting a risk assessment? What is the participation of the policy committee? Do all members need to be involved or only some?
Okay, thanks, Sarah. It's a good question. So the regulations require the employer and the policy committee to jointly conduct the workplace risk assessment, but that's a really sort of broad direction. So if you look to the guidance document on the ESDC website, it does say that the employer and policy committee need to decide sort of jointly how to go about conducting this process. So really, in our view, I think what that means is that the employer and policy committee have some flexibility to decide how to conduct an assessment, including actually, who is the person on the ground conducting the assessment. I think that the basic requirement is that the policy committee be consulted and alongside the employer have overall oversight of the process. But certainly what we typically see is that a worker member of the policy committee, along with an employer rep, conducts the assessment. But I think even prior to that, it's really important for the employer and policy committee to discuss together, how many risk assessments do we need? Who's going to be conducting these risk assessments? What method are we going to be using? Are we going to be doing surveys? Are we going to be using checklists? And what's the schedule of completion? How are we going to prioritize our workplaces and so on? The SDC has a really good risk assessment tool on their website, and it sets out some really detailed questions and issues that should be addressed during the assessment. So I would encourage participants to take a look at that if they haven't done so.
Okay, great. Thanks, Cathy. Here's another question. Rebecca, I'll put this one to you. This is someone who's struggling with report writing. And asked if you could give some guidance about, tips for report writing.
Definitely. Yeah, that's a good question. Perhaps I'll focus on three maybe common mistakes that people make when they're report writing and maybe provide some tips on how to avoid those mistakes. So I think I would say the first mistake in report writing includes when investigators omit information or evidence, perhaps because they believe that it's not relevant, or when they forget to, show your work. And so as a best practice, I would advise that it's best to draft your investigation report as though the person who is reading it has no context or understanding of the factual background of the complaint or the evidence that would have been presented. And in many situations, the reason you want to do this is because a report may end up in the hands of those beyond your initial intended audience. And therefore, you want to make sure that you clearly demonstrate the process that you followed in your investigation and demonstrate how you came to the conclusions that you reached. And this is especially important, if a claim is filed later with a court or tribunal, that court or tribunal will review and evaluate your report. And ultimately, that report is the main evidence it can rely on to determine, for example, whether you were procedurally fair in your investigation or the strength of your findings. And therefore, I always believe it's better to err on the side of caution in a report and include more detail rather than not enough. And you want to make sure that all potentially relevant evidence is included in your report and demonstrate in detail how the evidence that you reviewed is related to your findings and how you got there. And I think a second comment I'll make, and Catherine had discussed this as one of her pitfalls in our section on intersectionality, is when investigators place overemphasis on similar fact or character evidence. And so, for example, similar fact evidence is the use of past misconduct for the purpose of inferring that a person has engaged in behavior that's currently being investigated. So we have come across, or I've come across situations where the complainant may not necessarily be a model employee. Perhaps they have engaged in misconduct in the past, but that fact in and of itself does not mean or does not invalidate their current complaint. So we need to focus on, the actual allegations before us and the information before us. The fact that a complainant has engaged in prior misconduct is not necessarily relevant to whether or not perhaps their allegations are substantiated in this case. And again, while we maybe want to make note of these things in our report, as investigators, we need to make decisions and conclusions based on the facts and evidence before us. And maybe a final tip I'll give is, and this may not seem like a big deal, but proofreading is so important. I think some investigators underestimate just how important it is to proofread your work. A report that is full of errors may speak to your credibility as an investigator, and therefore you want to make sure that you give yourself enough time to proofread and look over your work and make sure it accurately represents your process, the process that you followed.
Okay, great. Thanks, Rebecca. That was really helpful. Here's another question that has come in. Is it a legal requirement in all provinces in Canada to provide a summary to both the complainant and the respondent after each interview to gain their agreement of what was discussed. I'll take a crack at that one. And then Katherine, if you have anything to add. It is not a legal requirement to provide a summary or your notes to every person you interview to get their sign off. There's different approaches you can take when you're interviewing people. One is you can go away and create a written statement, which you will then send to them for, review and signature, and they may make changes. Another thing that I've seen done is to go over your notes with the person in the interview and then have them, tell you if there are changes or things they want to add, and then have you sign them. Or have them sign the notes. And then the other thing I've seen is lots of investigators just take really good notes and then rely on those notes themselves. Many people think that it's, the written statement that's created and signed off is, is a best practice. But I know investigators who conduct, very good investigations who do have used all three approaches. So there isn't any legal requirement. And it's really, you want to reduce the chance that someone's going to change their story at a later point. So, there are different ways you can achieve that, but there's no legal requirement that I'm aware of. Katherine, do you have anything to add on that?
I would add, in the last year, Sarah, I have been involved in investigations where we have taped it's been on Zoom or it's been on Teams, and the parties have agreed that it will be taped and that's the record. I think there's two schools of thought on that. I haven't typically recorded, but happened to be doing an investigation with a co-investigator, and it was his practice and is his practice. And I kind of liked it. It allowed me to be a little more focused in on what was being said, as opposed to making sure I was getting everything down. So that's another option. And of course, it requires people to consent.
Great, thanks. Okay, the last question, because we don't want to go too far over. Katherine, maybe I'll send this one to you. Someone asked, when you're selecting an investigator, do you have any guidance on what makes a good investigator?
Yeah. Well, first of all, a good investigator would always attend a Fasken session on investigations. That's a joke. I can hear uproarious laughter through the airwaves. Seriously, though, I think what's key to a good investigation or a good investigator is he or she must have the time and the attention available to devote to the investigation. I've seen a lot of investigators who are way too busy and things are rushed or are not dealt with quickly. And there is a saying in the law, which I agree with, and that is justice delayed is justice denied. So the good investigator will only take on a brief if he or she has the time and ability to do it. Sarah, you talked earlier about how important it is to be able to establish rapport and be a good listener, be an active listener, ask questions, be mindful of people's sensitivities or intersectionality, be respectful for all. And finally, I would say whether an external or an internal investigator, it's really important that that individual be objective, be seen to be objective, but be actually objective, to do what they are asked to do, which is to assess credibility and then to make findings of fact, to draw conclusions, because that's what you're being asked to do. Sometimes the temptation is like, well, I wasn't there, so I don't know what happened, and just kind of leave it at that. That's not good enough. It's not good enough for the employer. It's not good enough for an investigation. A good investigator is going to do all that they can to fairly draw conclusions and make findings of fact.
Okay, thanks, Katherine. Well, we want to be respectful and mindful of your time. So on behalf of the whole panel, I'd like to thank you for attending today. We hope you found it helpful and that you got some value from it. Your feedback's really important. So just a reminder to fill in that survey. It's the way we make sure that we cover topics that are useful to you and things you're grappling with. Our next webinar is going to be held on March 29th. So keep an eye out in your inbox for that, or you can look at the Fasken Institute section of fasken.com. So again, thanks for attending today. We hope you got some value, and I hope you all have a good afternoon.